Good day. My name is Keith Schiller with the Schiller Law Group. I'm an estate planning attorney in Alamo, California. I would like to address with you today the matter of joint tenancy and how it can be bad for your estate plan. Joint tenancy is a form of title in which ownership automatically passes to the surviving joint tenant on the death of the first joint tenant to pass away. Perhaps that result's intended. Oftentimes it is not. I commonly see people prepare wills or living trusts that lay out the desired estate plan. However, joint tenancy ownership may or may not be consistent with that estate plan. If it is truly intended that the ownership pass to the surviving joint tenant on the death of the first joint tenant to pass away, then joint tenancy may be an appropriate way to handle the estate planning for that asset. However, oftentimes joint tenancy is inconsistent with the estate plan and it has negative income tax costs associated with it. I liken the use of joint tenancy to the film Christmas Story. Christmas Story is now the most popular and often seen story during the holiday season. The movie stars Peter Billingsley as Little Ralphie, and Ralphie wants a Red Ryder BB gun. And he's just dying to get that Red Ryder BB gun. His parents warn him, "Don't get it, you'll shoot out your eye." His teacher, when he writes an enthusiastic essay about this gift that he's looking forward to, she warns him, "Don't get it, you'll shoot yourself in the eye." Even Santa Claus warns him, "You don't want that, you'll shoot yourself in the eye." And sure enough, Ralphie gets that gun, and on Christmas Day, he takes his first shot, and it ricochets off the target, and the little BB goes into his eyeglasses and shatters his glasses. Well, it's a wonderful story, and everything works out well. But for estate planning, I liken joint tenancies to the movie Christmas Story and the warning, "Don't get that gun, you'll shoot out your eye." Why is that? It's because joint tenancies are commonly problem creators, not problem solvers. And notwithstanding the warnings that attorneys or accountants may give to their clients, many individuals still want to use joint tenancy title. So let me go through some of the problems. And to illustrate it, I have a photo of my 3 children. I have 2 daughters and 1 son. And let's say that I've passed away and my wife is now advanced in her years and she wishes to have a bank account in joint tenancy title with one of the children. Let's say it's with the daughter who's living closest to my wife. Now my wife is doing this joint tenancy for the purposes of having someone be able to co-sign checks and to help her with managing the particular bank account. Yet the impact of joint tenancy ownership is far beyond that. What the joint tenancy ownership would do is cause whatever value is in that bank account to pass to the daughter who's on the account with my wife, rather than to be divided among the 3 children, which let's say is the general estate plan. So let me just run the math with a simple example. Let's say that there's a net worth of $600,000, which will be divided on the death of a surviving parent among the 3 children. So each child would be receiving $200,000. However, there's a joint tenancy account, and that joint tenancy account is with $100,000. Now what happens is that one child is entitled to sole ownership of that $100,000, leaving only the remaining $500,000 to be divided equally among the 3 children. Thus, of the general estate, each child receives $166,000, while the child who is on the joint tenancy title also receives an additional $100,000. The estate is not equally divided. Now, it may or may not be the case that after the death of the parent, the daughter who is on the joint tenancy title will agree to share that money with her siblings, but that may not be the case, and often it isn't. In fact, joint tenancy in this type of ownership is something that the trust litigation attorneys love to see, because it's a creator of conflict among family members, which then leads to post-death litigation. Now, if you're establishing a bank account and you want to have assistance by having a child be able to sign on the account, you don't need to have joint tenancy ownership for the property to pass to that child on death. You can have an account in your own name with another person as the signatory, or use a living trust. These are common ways in which to avoid the problem. Now, the issue of the inequitable or inconsistent distribution of the estate is only one problem created by joint tenancies. Another would be merely placing a third party, such as a child, on title, can create other problems for you even while you're living. For example, if your child has a divorce or has creditor issues, you can then run into fights over whether that account is community property in part, or whether the creditors of that child then have claims against this bank account. And that can get into a lot of litigation and a lot of dispute between yourself as an innocent holder of the account, creator of the wealth, and third parties who are seeking to reach assets of your child. Another problem with joint tenancies is that they receive less favorable tax treatment on death than does, for example, community property, even if community property passes outright to a surviving spouse. Other problems for more wealthy estates arise with joint tenancies because of the disadvantageous treatment afforded to joint tenancy gifts, which then arise when the creator of the joint tenancy, the older parent, let's say, passes away. There is typically a state tax inclusion, there's a disadvantageous rule, and the gift tax savings that you might have thought that the joint tenancy would then create will be lost, commonly so. Property remains in joint tenancy during the life of the owners. Joint tenancy can also be disadvantageous when held between spouses, if the property would otherwise be community property. This is true on the death of the first spouse to die. Normally on death, there's a new income tax basis equal to the value as of the date of death. So even though the property was purchased for a much lower value, if the asset is community property, there is a new income tax basis on both halves of the property. However, with joint tenancy between spouses, there's a new income tax basis only on the deceased spouse's one-half interest. Let's look at the graph with a simple example of this point. Let's assume that years ago, a couple purchases a residence for $500,000. Each of them would have a $250,000 income tax basis. Now let's say over time, the home goes up in value to, let's say, $900,000 when the first spouse dies. As a result, the decedent's one-half interest will have a new income tax basis of $450,000, that being one-half the $900,000. And there's a carryover basis of the $250,000 for the surviving spouse. Add these two halves together, and you have a new income tax basis on death of $700,000. On the other hand, if that same residence were owned as community property, on the death of either spouse, the new income tax basis would be $900,000. Higher income tax basis is beneficial because it reduces the gain and tax that will arise on a subsequent sale. So let's look at joint tenancy much in the way as we would Ralphie's gun, Ralphie's BB gun in the movie Christmas Story. It's a way in which title to property can shoot your estate plan in the eye. So I'd recommend to you, Think carefully before creating joint tenancies and consider whether it's doing what you really want it to do, or if it's being used or might be abused as a form of passing title on your death, inconsistent with your true wishes. Thank you.